If your life or the life of a loved one has been forever changed by a preventable medical error in Iowa, there are critical legal requirements and tight deadlines that you must understand, and medical malpractice insurance companies are counting on you not to know them. I'm attorney Tim Summelroth of RSH Legal. We've been helping families fight for justice in Iowa medical malpractice cases for over 27 years. Medical malpractice cases are among the most difficult injury claims to win, which is why we must be highly selective about which cases we accept. If you or a loved one has suffered serious permanent injury or death due to medical negligence, get a free consultation with a law firm you can trust by calling us at 319-895-1847. After a medical error, you need answers, and you need them now. Let me walk you through exactly what you should know about medical malpractice claims in Iowa so that you can make the best decisions for your family during this devastating time.
Do you have a case?
You might have a medical malpractice case if a health care provider's negligence caused serious permanent injury or death in Iowa. But proving malpractice requires meeting specific legal standards, and not every bad medical outcome qualifies. Legally, medical malpractice occurs when 4 elements exist: a treater-patient relationship, the provider failed to meet the accepted standards of care in their medical specialty, the failure directly caused your injury, and you suffered actual damages. Common examples include misdiagnosis or delayed diagnosis of conditions like cancer or heart attacks, surgical errors like operating on the wrong body part or leaving instruments inside patients during surgery, birth injuries causing cerebral palsy or nerve damage from improper delivery techniques, anesthesia mistakes, medication errors, or the failure to obtain informed consent before medical procedures. Understanding the standard of care is critical. This means the level of treatment that a reasonably competent provider with similar training would have given under similar circumstances. Now, not every disappointing result constitutes malpractice. Medicine involves inherent risks, and providers are only liable when they fail to meet professional standards. Beyond the legal requirements, RSH Legal has strict case acceptance criteria because Iowa law makes these cases extremely expensive and very difficult to win. We can only help if your case meets these requirements. The injury must be very serious, resulting in permanent, disabling injury or death. The injury must be directly related to the malpractice, and the malpractice must have occurred in Iowa within the last 18 months unless it involves a birth injury. You must not have been represented by another lawyer already or already had your case filed. Your case cannot involve solely hospital-acquired infections, bad bedside manner, or injuries that only frightened or angered you, or problems that might happen in the future. If your situation meets both the legal requirements and our firm's case criteria, document everything you can and contact us for an immediate evaluation.
What is your case worth?
The value of your medical malpractice case depends upon the severity of the injuries, the strength of your proof, and Iowa's legal caps on certain damages. But Iowa law also includes unique limitations that can reduce recovery compared to other types of injury cases. You can recover economic damages for quantifiable losses like medical expenses, future medical treatment costs, lost wages, loss of earning capacity if you can't return to your career, funeral expenses and burial expenses if your loved one died, and costs for necessary medical devices or long-term care. These economic damages have no cap in Iowa. However, Iowa has an unusual and harsh limitation on economic losses. You cannot recover medical bills incurred after the malpractice occurred if they were paid by insurance. So this means if negligent surgery caused complications that required $200,000 in additional surgeries and treatment, you cannot recover those $200,000 in medical bills, even though the malpractice directly caused them, if that $200,000 was covered by health insurance. This makes Iowa medical malpractice cases worth significantly less than similar injury cases. Now, non-economic damages compensate for things like pain and suffering, emotional distress, loss of enjoyment of life, permanent disability, disfigurement, or the loss of consortium. Iowa's 2023 law caps these damages at $1 million when you prove substantial or permanent loss of bodily functions, substantial disfigurement, loss of pregnancy, or death against individual healthcare providers. When your case includes a hospital as a defendant, that cap can rise to $2 million. For less serious injuries, the cap is only $250,000. Now, these caps increase by 2.1% annually starting on January 1st of 2028. Punitive damages may be available when the healthcare provider's conduct was willful, wanton, or showed reckless disregard for patient safety. But these cases are rare and aren't subject to the non-economic caps. Now, given these limitations and the high costs of proving these cases, understanding realistic case value helps families make informed decisions about whether to pursue a legal action.
Do you need a lawyer? Yes.
But understand medical malpractice cases only have a 23% win rate for patients at trial, making these among the most difficult and expensive cases in Iowa law. Self-representation is virtually impossible. Here's the sobering reality. Recent studies showed that patients win only 23% of medical malpractice cases that go to trial before a jury. The defense wins over 75% of the time. This happens because juries often place doctors above others in our culture. Complex medical information can confuse jurors, and Iowa law makes these cases harder to prove than the other injury claims. For example, Iowa requires a certificate of merit to proceed with most malpractice lawsuits. This means that a qualified medical expert with the same training as your defendant must review your case and sign an affidavit stating that there's reasonable basis to believe that malpractice occurred. Finding these experts is difficult. Most Iowa doctors won't testify against their colleagues, which requires expensive out-of-state experts. These experts charge thousands of dollars just to review records and may refuse to testify if they don't believe malpractice occurred. The costs of a medical malpractice case can be staggering. Investigating a medical malpractice case and taking it to trial typically costs $100,000 or more. This includes assembling thousands of pages of medical records, paying multiple expert witnesses to review those records and testify, taking depositions, retaining specialists for different medical issues for your case, and preparing comprehensive trial exhibits. Few families can afford these costs up front. If you represent yourself, you must follow the same court rules as experienced lawyers, understanding all of the complex deadlines, taking witness depositions, filing motions correctly, negotiating with insurers, participating in mediation, and possibly presenting evidence at trial. Missing even a single deadline can get your case dismissed, regardless of its merits. Now, given the difficulty and expense, experienced legal representation isn't optional. It's essential for any realistic chance of winning a medical malpractice case.
What will a lawyer cost you?
Most Iowa medical malpractice attorneys work on contingency, meaning you pay nothing up front and the lawyer only gets paid if you win. But understanding how this works is critical given the high costs involved. Here's how contingency fees work in malpractice cases. Your attorney advances all investigation and litigation costs, typically $100,000 or more if it goes to trial. These costs include ordering complete medical records from all providers, hiring medical expert witnesses to review those records, often multiple experts for different specialties, each charging thousands of dollars, getting the required certificate of merit from a qualified expert, taking depositions of the defendant doctors and their experts, retaining additional specialists to testify at trial, and preparing comprehensive medical exhibits for court. Now, the contingency fee arrangement is essential for medical malpractice cases because the costs are prohibitively high for most families, especially when dealing with ongoing medical needs or grief. Without contingency fees, only wealthy families could afford to pursue justice when doctors make devastating mistakes. If you lose your case, and remember, the defense wins over 75% of medical malpractice trials, you don't have to pay back these costs. The attorney absorbs the entire dire financial loss. This is why medical malpractice attorneys must be highly selective about which cases they accept. They are risking substantial money on every case. If you win through settlement or a trial verdict, the attorney's fee is typically a percentage of recovery, often 40%. The attorney also recovers the cost that they advanced from your settlement or award. This arrangement aligns your attorney's interests with yours. It also makes justice accessible for families regardless of their financial situation. How long will this take? Medical malpractice cases in Iowa typically take at least 2 years to resolve from the date that you first contact an attorney, and cases going to trial often take several years. Understanding this timeline requires knowing the stages involved in your case. When you first contact RSH Legal, we will begin a comprehensive investigation that can take up to 6 months before we can even decide whether we can take your case. We must order your complete medical records from all providers who treated you, often thousands of pages that can take months to obtain. We send those records to qualified medical experts for review. These experts must have the same training and experience as the doctor who hurt you, making them expensive and sometimes difficult to find. The expert then carefully analyzes whether the standard of care was met and whether any deviation from the standard of care caused your injuries. Now, if the expert determines that you don't have a valid medical malpractice case, we will have to decline representation, protecting both you and us from pursuing a case that we cannot win. If the expert confirms that malpractice occurred and that your injuries are serious enough to justify the costs, we will offer to represent you. After we accept your case, we obtain the required certificate of merit from our expert witness. That's an affidavit stating that there's a reasonable basis to believe that malpractice occurred. Iowa law requires this certificate to be filed for most malpractice cases. We then attempt pre-lawsuit settlement negotiations, if we still have time, with the medical provider's malpractice insurance. If a fair settlement offer is not made, we file a lawsuit before the statute of limitations expires. Once the lawsuit is filed, discovery follows. Both sides exchange information through written questions, document requests, and depositions. Medical malpractice discovery is extensive, often involving depositions of multiple doctors, nurses, and expert witnesses. This stage can easily take a year or more. Many cases proceed to a mediation after this, when both sides and a neutral mediator attempt to reach settlement. If the mediation fails, trial preparation begins in earnest, which is an intensive process of organizing your complex medical evidence and preparing expert testimony. Waiting for an available trial date can often add up to a year. Now, this timeline is long, but thorough preparation gives you the best chance against well-funded medical malpractice insurance companies.
How do you find the right lawyer for your case?
Finding the right medical malpractice attorney requires asking specific questions that reveal genuine trial experience and the resources necessary for these expensive, difficult cases. Start with the most critical question.
Have you tried medical malpractice cases to verdict in Iowa?
Many attorneys claim that they handle medical malpractice cases, but have never actually taken one to trial. Medical malpractice insurance companies know which lawyers settle every case or lack trial experience, and those lawyers' clients often receive lowball settlement offers. You need an attorney with proven trial experience because insurers respect firms that are willing and able to take cases to verdict. Follow up by asking,
what is your win-loss record in malpractice trials?
While no attorney wins every case, and remember, patients only win about 23% of malpractice cases nationally, you want someone who succeeds more often than average. At RSH Legal, we've won more malpractice trials than the national statistics would predict because we are highly selective and only take cases that we truly believe we can win. You also want to ask about the lawyer's access to qualified medical experts.
Do you have relationships with medical experts who are willing to testify against other doctors?
Finding experts is one of the biggest challenges in malpractice cases. Most Iowa doctors won't testify against their colleagues, requiring out-of-state experts who don't fear professional retaliation to testify on your behalf. Attorneys without an established expert network will struggle to prove your case. You also want to confirm that the lawyer has substantial financial resources. Ask,
Can you front up to $100,000 or more in case costs?
only well-established firms can afford to invest that much in a single case. Attorneys without these resources may push you to settle cheaply rather than properly investigating and litigating your case. Ask about the attorney's knowledge of Iowa malpractice law. Are you familiar with Iowa's Certificate of Merit requirements, the statute of limitations for malpractice cases, and how the 2023 damage cap works? These Iowa-specific rules can make or break your case. Finally, you want to assess their honesty and compassion. Medical malpractice attorneys should be forthright about your case's strengths and weaknesses, realistic about the difficulty of winning, and compassionate about your suffering, while remaining professional enough to handle emotional testimony that these cases require. The right attorney gives you the best chance in an uphill battle.
How soon do you need to call?
Call an experienced Iowa medical malpractice attorney within 12 months of when the malpractice occurred, even though Iowa's statute of limitations is generally 2 years from when you discovered the injury. Here's why timing is critical. Iowa's statute of limitations for medical malpractice is generally 2 years from the date that you discovered or reasonably should have discovered the injury, but no more than 6 years from the date of the Malpractice Act itself. This discovery rule matters because some injuries aren't immediately apparent, like when a surgeon leaves an instrument in after a surgery, or when birth injuries don't fully reveal their impact until a child starts to miss development milestones. Important exceptions exist. If a foreign object was left inside your body, if the provider engaged in fraud or concealment about the malpractice, or if the victim was a minor, different deadlines may apply. Birth injuries have special rules. These exceptions are complex, making an early consultation with an attorney essential. But here's the practical reality. Even though you may have 2 years, waiting anywhere near that deadline is dangerous. Most medical malpractice cases require at least 6 months of investigation before an attorney can determine whether to take your case. Your attorney must gather all medical records, send them to expensive expert witnesses for review, obtain a certificate of merit confirming that malpractice occurred, and prepare the case for filing. Now, this process cannot be rushed. Experts need time to thoroughly analyze complex medical issues. Evidence can also deteriorate over time. Memories fade, witnesses relocate, medical records become harder to obtain if providers close or transition to new record systems, and critical documentation may be destroyed according to routine retention policies. Most concerning, if you wait too long and then contact a lawyer, they may not have enough time to properly investigate before the deadline, forcing them to decline your case even if valid malpractice occurred. Protect your rights by calling early, especially for birth injury cases where the full impact may not be known for years.
What happens after you hire us?
After you contact us about a potential medical malpractice case, we begin a careful process that is different from other injury cases because we must first determine whether we can help you before we can formally accept your case. The investigation and evaluation phase has to come first. When you call, we conduct a free initial consultation to understand what happened and to see whether your situation potentially meets both the legal definition of malpractice and our own firm case acceptance criteria. If we believe that your case warrants investigation, we will order your complete medical records from every provider who treated you, often thousands of pages documenting your care before, during, and after the malpractice. We send these records to qualified expert witnesses who have the same training and experience as the doctor who hurt you. These experts carefully review every aspect of your care to determine, did the provider violate the standard of care? Did that violation directly cause your injuries? Are your injuries serious enough to justify the substantial costs of litigation? This expert review can take several months and cost thousands of dollars. If the expert determines that you do not have a valid malpractice case or that your injuries are not severe enough to justify justify the costs. We must ethically decline representation. We'll explain why we cannot help and may suggest other steps you can take. Now, if the expert confirms malpractice occurred and your injuries do meet our criteria, we will offer to represent you and work to obtain a certificate of merit, which is the sworn expert statement Iowa law requires before most malpractice lawsuits can proceed. Once we've accepted your case and get the certificate of merit, we will attempt pre-lawsuit settlement negotiations with the malpractice insurance company if there is time. We present our evidence and demand fair compensation. Some cases can settle at this stage when insurers recognize the strength of our proof and our willingness to go to trial. If fair settlement cannot be reached, we will then file a lawsuit before the statute of limitations expires. Discovery would then begin, where both sides exchange detailed information through written questions, document requests, and depositions of doctors, nurses, and expert witnesses. Medical malpractice discovery is extensive and can often take a year or more. After discovery, we often attempt mediation, which is where both sides and a neutral mediator work towards settlement. If the mediation fails, we prepare your case for trial, organizing complex medical evidence, preparing expert testimony, and developing a courtroom strategy to present your case to a jury. Finally, we present your case at trial, where a jury decides whether malpractice occurred and what compensation is fair. Throughout this process, we keep you informed about the important developments while handling the complex legal and medical work that these cases require. We work to resolve medical malpractice cases as efficiently as possible while still getting you the full compensation you deserve. The sooner we start, the sooner we can begin investigating your case and fighting for your family's future. If you would like to set up a free consultation with an experienced attorney who will honestly evaluate your case and fight for justice if we can help, please call us today at 319-895-1847. Our conversation is confidential, costs you nothing, and can help you understand whether you have a valid Iowa medical malpractice claim. If you found this video helpful, subscribe to this channel and make sure you watch this next video.